Welcome to Warwick Business School's Core Insights podcast on FinTech. This is the second in a series of podcasts on FinTech with the school's Gillmore Centre for Financial Technology. With the help of the Centre's world-class researchers and professors and alongside guests from the FinTech industry, we're exploring the big issues as the financial sector continues to be disrupted by and grapple with exciting new technologies. I'm Natasha de Teran, a former journalist and author of the book The Payoff: How Changing the Way We Pay Changes Everything. I will be your host, asking the questions to find out just where FinTech is heading. Today, we're going to be talking about crypto. The question we're asking ourselves is, will cryptocurrencies survive the incoming regulation? I'm joined by Luigi Cantisani. Luigi is a tech lawyer working on blockchain and crypto assets. He's a PhD student at Warwick Law School, and he's a part of the Gillmore Centre. I'm also joined by Stephen Murray. Stephen's head of IP and tech disputes at the law firm HRC Hewitson. Stephen leads on the firm's crypto asset recovery initiative, and in September last year, he recovered a stunning $1.5 million worth of Bitcoin for a client who'd been scammed. Welcome to you both. And thank you for helping us answer this question. So crypto has been described and is, and probably will do for a time yet, been described as the Wild West. And as the title of this discussion suggests, regulation is headed each way. But before we get into the whys and the wherefores and so on and so forth about this regulation, I want to ask you both straight up and down questions. You've been deeply immersed, both of you, in this market, slightly different aspects, but both from the legal perspective. Do we need regulation?
This is a very tricky question, but yeah. In this case, I think that it depends on what we mean by regulation, because regulating crypto is something to be unpacked a bit. What are we really trying to regulate? The crypto assets as a phenomenon rooted in finance and in electronic trade in general, or are we regulating more the technology underpinning the phenomenon?
I'm glad to have extracted an up or down yes or no, which was a yes from a lawyer. You're right up there as a profession with politicians on refusing to give straight answers. But Stephen?
I would certainly say regulation is needed. The form of that regulation and how it will apply needs some thought, but it's certainly a way of helping the consumers protect themselves from some very unclear methods of investment and how they can easily be scammed.
It has been suggested in the UK by the Treasury Select Committee, I think, that crypto should actually be regulated as gambling rather than as a financial service or asset. Shall we start off with that as a starting point? Why would you regulate as a financial, or would you regulate financially? Maybe, Stephen, you'd have it as gambling.
I think gambling is probably an inappropriate way to classify it. I see that there is a risk, and certainly if you acquire a digital asset that increases in value, then you can make a significant windfall as well as significant losses.
Much like a stock or share.
Exactly. So, but why are stock and shares not regulated by way of gambling? So I think to classify it as gambling would be the wrong move. I think there's definitely a need to regulate how the assets are promoted in order to protect the individuals, to make sure that they're going in there with their eyes open.
Talking about the promotional aspect, Stephen, we see those of us that live on social media might see a fair amount of crypto promotion on social media. So we're seeing it on a device that's however big this is. This is a big one because my eyes are old. It's very fast. It's a very small screen on which to display quite a lot of complex information. When you're thinking about the promotional aspects that need to be addressed, what are they in particular? Is it the medium, the message, the complexity of the products and the audience that they're being promoted to, or is it all of those things?
It is all of those things. The clients I've worked with over the last year or two have almost consistently been duped by an advertisement that's come via Facebook, whether that's been promoted by a deep fake video that's been created by using Martin Lewis as a sort of guru in such financial investment terms. People see him promoting it, they feel that it's a safe investment that they could carry through with. But it's clearly not. He had he provided no endorsement for such things. But the technology is now out there with AI to manipulate images, so people don't really know what to believe when they're seeing these promotions. I think there's an opportunity to regulate social media providers to ensure that adverts that are pushed through their medium are by legitimate organizations. And when I say legitimate organizations, those organizations who have gone through the application process to be regulated to provide promotions of digital assets. The FCA, the Financial Conduct Authority here in the UK, is quite clear that they are high-risk investments, and therefore, if you're promoting them, you need to be part of their regulatory regime.
So, Luigi, turning to you, and you've been deeply immersed in the EU conversations and the development of the legislation and the law in the EU. Is it very much from an investor protection standpoint that the authorities are coming at this problem? And are they doing so in a manner that you think will be successful?
I think that from the way crypto assets are promoted play a crucial role. And as a matter of fact, even the recent regulation issued by the European Union, which is the MiCA regulation, which regulates certain crypto assets, poses certain obligations over token issuers relating to the way crypto assets are promoted. And this has been a concern since the advent of these assets, because also the way you promote such assets can make a difference to the legal qualification of these assets. In simple terms, if what I'm promoting is perceived by the end consumer as a security, as a proper financial instrument, in other words, you take a risk by purchasing the assets, and in turn, you could get in the future some sort of passive income. This kind of elements could qualify the asset itself as a proper security. So it completely changed the laws that could apply to the asset. By contrast, if the asset is not promoted as a financial instrument, is more, a tool to play within a video game, or is it a key to access some kind of services in a digital platforms? That's different. It falls within, the label of utility token, maybe. So it's a different landscape. And the MiCA regulation makes this distinction in a very strict way. It even says that if the crypto asset does not falls within the definition of financial instruments, other legislative acts should apply, not the MiCA regulation. So promotion makes a huge difference.
As a wordsmith, I've spent a good part of my career battling with lawyers on words. This is one of the few times that I would actually agree with the legal profession in that the terminology is so key, and just the term cryptocurrencies, I think, is extraordinarily misleading to those that would think that a currency is exchangeable immediately. Now, there is a sort of the other side of the coin is the so-called halo effect that regulation can give, and by the very stint of a regulator implicitly saying that an asset is a financial asset. If it's crypto, a crypto asset is a financial asset, and therefore could actually be misleading to investors and lead them to think that the backing is perhaps greater than it is. What do you think the dangers are there, or do you think that's overstated?
I think that the danger that comes with regulation and the consumers having greater faith because it has become a regulated activity, or the definition of the asset has become a little bit more clear. It's a risk worth taking, and I think that if the way in which the providers of these assets and the way in which they interact with each other has come under the scrutiny it needs to, then those assets will be legitimized and will be legitimate to use. And we may find ourselves in a situation where over time we move away from government-backed currencies and to a more global economy.
Gosh, That would that's a topic for another podcast, I think. I want to pick you up on something you said there. It's a risk worth taking. Is it a risk worth taking so that the crypto industry can develop, so that investors can be protected, or so that different jurisdictions can get a lead on other jurisdictions?
I think picking up on your point about different jurisdictions taking a lead internally, within the crypto space generally, there is a lot of competition. There's thousands of different varieties of cryptocurrencies, as well as a variety of different crypto assets. That has led to competition that's developed a bit more confidence in the core crypto assets. So Bitcoin, Ethereum, that by their very nature enables them to establish themselves as a bit more of a reliable commodity. I feel that if you enable different jurisdictions to have the ability to create, I suppose, safe harbors, in the sense that if you're regulated by the UK, then there's a greater respect for what you're doing, and therefore you have a greater legitimacy, can be a good thing. I know that there's the steps that the US are taking are causing some of the crypto providers to move away from the US because the clarity isn't there as to how they're going to be regulated. So we already have that jurisdictional competition where businesses are thinking, well, where should we set up? Now, the opposite side of that is there's going to be some jurisdictions which are less concerned about how things are regulated and how consumers are protected, and that will create opportunities for those of nefarious intentions to locate there, and in the hope that they can continue their nefarious activities. But that's always been the case, and I don't feel that the crypto world's going to be any different from the real world.
No, and we have to remember all this is live and kicking in the TradFi world as well. Luigi, I just want to go back to the words issue. In preparation for this, I was listening to one of your previous podcasts where you were talking about smart contracts, which I know you've done a lot of work on smart contracts. And a contract, as we understand it in the old world, is a legal thing, often binding, mostly binding, and a smart contract isn't. And yet they can be completely determinant in a crypto asset's performance, behavior, realization, and so forth. To what extent can the regulation get into that in a useful way, in a protective way?
Something that I'm exploring actively. It's something that I'm writing about in my thesis, and it's something I'm reading a lot about. So at this moment, I think that it's still connected with what I was talking about early on during this podcast, like separating the technology aspects from the phenomenon actually regulated. I think that regulating in general works better when it tackles technology by setting goals. So let me say this. We have certain regulatory goals to be achieved. Okay, let's set up general criteria. So very broad obligations, very broad provisions, and let market players do their best to achieve those goals according to a risk-based approach, which is something that we are already experiencing with other regulations, such as the GDPR. Most of the times, the GDPR does not contain provisions which dictate technical requirements or performances requirement. It's more about goals. It's more about accountability. I think that that's the best way to deal with technology, because at the end of the day, technology constantly evolves. We might set up requirements today, and those requirements could be completely obsolete tomorrow. When it comes to other aspects more rooted in finance, such as promoting financial instruments, communication, marketing, admission to trade, those things could, in my view, could be regulated with a more strict approach, because, it's something that we have already experienced, just in a different market.
So just apply those rules, or import or apply those rules into the crypto sphere.
Yeah.
As I've got two experts, one from each side of the big divide that now is the channel. Luigi, you've looked at the approach closely in the EU, and Stephen in the UK. What are the key differences that you see, and benefits or criticisms you'd have have either approached, either the UK or the EU's?
I can't say that I've looked at it as intently as maybe Luigi has. The sort of cross-jurisdictional issues that I face tend to be because the opponents are operating in jurisdictions outside of EU and UK. So I know that there is difficulties in that regard. But I'm welcome to learn more about Luigi's views as to how the EU are approaching things. I mean, I'm aware from the UK that the FCA is taking a charge in terms of trying to regulate the promotion of the assets, but not so much in terms of the transactions that take place and how they operate within the marketplace.
So, Luigi, the EU was really, stormed out of the gates as a major jurisdiction with a major piece of legislation. It's a big package. It was early. What was the trigger, and why was the EU so much faster than everybody else? It's not always famed for legislating quickly.
I think it's because in these recent years there is a huge attention on innovation in general. So data, artificial intelligence, online platforms, and digital services in general. So there is a lot of stuff happening in that regard. But I think that there was also a lot of pressure from the member states. For instance, Stephen mentioned that the FCA is concerned about promotion, and this has been a concern for the European financial authorities as well. But given that they didn't have proper regulation to rely on, what they could do at best was applying pre-existing rules to this new phenomenon, and what they usually did was stopping token offerings when they were promoted without respecting other rules that usually apply to the promotion of financial assets. So this tension, I believe, lead the European Union to regulate quickly. And also, this is my personal belief, I think that if you position yourself on the global market first, you have an advantage in terms of aspiring rule. Let me use again the GDPR as an example. Okay, the GDPR has an extraterritorial scope of application. It means that any time you offer products and services to citizens located in the European Union, you are subject to the provision of the GDPR, no matter if you're based in the US. So in a kind of sense, it's like you are exporting your rules, and companies that want to compete in the European Union market have to meet those standards if they want to play in that market. It's the so-called Brussels effect, understood as a race to the top. Okay, I want to meet those requirements because I want to compete there. What they're doing with the MiCA regulation is not that different. As a matter of fact, the MiCA regulation applies to players who engage in the European Union, no matter where they're based, where they are incorporated. And by doing so, by legislating on this so quickly, they are again setting a sort of standards that players in this industry could try to meet if they want to stay in the European Union market. This is my belief.
So that's interesting. So I think there are some that might say maybe even in the US that some countries export industries and other countries export regulation. There's some in Europe that might say there's some countries that do both.
Yeah, for instance, California. In fact, we also talk about California effect because they are quite active on regulating about privacy, consumer law. So it's like they set a standard, and other countries try to emulate that standard later.
And do you think it could serve as a, whether the EU's one or the UK's, if and when we get there, do you think they could serve to actually attract and stimulate commercial activity and the growth of crypto industries here, or do you think there'll be a deterrent?
Just picking up on Luigi's point about the race at the top, when you set the objectives and there is an opportunity for an organisation to meet those objectives, then if they want to grow, that's what they'll do. If they perceive the lifespan to be assisted by continual investment from the consumer, then they're going to raise the bar that's being aim to meet the bar that's being set by the regulations. So I don't think it will be a deterrent. I think it will encourage organisations who want to be legitimate and continue in the future, because they're not going to be able to escape the regulations. Then it will encourage more organisations to go to those jurisdictions and seek to meet the objectives that are being set.
Would you agree, Luigi? Have you seen any evidence of that in the EU?
I think it's too early to talk about evidence, but what I will try to point out is that, there are different positions on regulating stuff in general rooted to technology. So, for instance, Joseph Schumter, used to say that regulating technology could affect in a not positive way inventing, innovating, and diffusion of technology. But many other theories have actually argued the opposite, that regulating could reduce risk, could make the products better as a result of setting up, higher threshold each time regulation intervenes. So I think that at this stage, it's too early to have a clear idea, but both the theories could work in conjunction, in a sense that small startups, could in fact be cut out from the market as a result of not being able to comply with requirements set by regulations. Some other players, the one who want to make the race to the top, could maybe make some positive stuff out of this, like improving, making stuff better, creating a more transparent market. And having a more transparent market could result in more trust, because at the end of the day, let's not forget that apart from us that we're talking today here and some other, crypto invested people, crypto is perceived as something to be scared of, in a way. So there's a problem of trust to be resolved here.
Well, going back to your earlier point about the two different effects of regulation, one stimulating, the other stifling, you don't actually need regulation, specific regulation, to behave as though you're regulated. There was ample legal advice that that any crypto provider could have taken in the UK or elsewhere. If this was a financial asset, how would I have to behave? That you don't need specific regulation to behave appropriately. You just need to look at the landscape in which you're operating, which I think brings us into the interesting question of how these two worlds will collide. You have two very, very different mindsets. One is more move fast and break things. The other is more move slowly and no mistakes. How are they going to interact together?
The point that Luigi made about the small startups being cut out of the market, I think that's most likely to happen. But if you've got an organisation who is looking to grow in this particular sector, they're going to look at what the regulations are, or what the regulations might be, and model their business approach according to that, so that they can grow. And being a smaller startup, there's a bit more agility to be able to adapt. Whereas if those organizations who've been a bit more longer established, they're going to struggle to adapt if they need to, taking your point that, when they came to this without the regulatory shadow looming over them, that they could have taken advice and structured their businesses accordingly. They may not have followed that advice. They may have not been able to work out what the best thing is to do. And then they may now be struggling with regulations coming in and having to adapt and not being as agile as the smaller businesses who start up. From the lawyer's perspective, it makes interesting opportunities to help businesses change their approach and hopefully be a part of their success rather than their downfall.
So, Andrew, I spent a good part of my time in the TradFi world, most of my time in the TradFi world. And one of the things that we worry about in payments is app scams, fraud, recovery of funds. And one of the things that's very difficult is recovering funds, particularly when they're cross-border. But you achieved the seemingly impossible recovery of £1.5 million, and it was a cross-border operation, if I understand right. It involved St Vincent and the Grenadines, Bulgaria, the UK. So lots of excitement in terms of cross-jurisdictional problems. How did that work, and does it hold a lot of promise for the future? Does it mean we just don't need to worry? We can invest in Aruba in crypto anytime we like?
Unfortunately, it doesn't mean you don't need to worry, but it does hold promise. I think the case I was involved in, the trace was quite clean in terms of being able to show the specific Bitcoin that left our client's account, legitimate account, and went through a number of different wallets until it ended up in the particular one that's operated by the Huobi exchange. In other situations, and where, say, Binance have been involved, it's not as easy to do the transactional trace because they approach it by mingling the funds when they enter into a digital wallet. So whereas we were able to show the transaction hashes that followed all the way through to the endpoint, with the likes of Binance and where there's wallets that commingle, there's the risk that we're not able to actually see what happens after that stage. Not all exchange providers are likely to be as amenable. So I don't think it's safe to say that you can relax, we'll be able to find it. I think that it's a lot easier to find. I think the technology that exists now in terms of the tracing and the analysis of those transactions, because it's an immutable technology, make it a lot simpler to trace as compared to other currencies. So I think there's definitely promise there, and some comfort can be taken from that.
So the first point of order for an investor would be to consider where the exchange is based that they're dealing with and how they're regulated.
There's a number of factors that an investor needs to consider is what is the legitimacy of the platform that they're operating on. If somebody is considering investing in cryptocurrency, they would be wise to consult the FCA to see if the organization who's behind the platform they're being invited to invest upon has had any warnings. I mean, there's a number of stay away, you avoid, this is not a regulated company. We've had reports of fraud notices on the FCA website. And so doing an initial search against that particular company before undertaking any investment with them is key. So the average consumer is more likely to think, oh, this looks fine. There's a nice shiny new website. There's a company registered in the UK. What's the problem? Yeah. But it's only when we dug deeper with the company that was regulated in the UK that we saw that, well, the only present it has is the post box address that they use to register the company with, and the main director, who's named, is based in St Vincent's and the Grenadines. It just started to look a little off. But then I've also got cases where the company were legitimately operating in the UK, but their methods were quite clearly geared to like a pyramid scheme, where they get more people involved and the investments come through, and then once there's a certain amount in the pot, they disappear.
But Luigi, what hope do you have for international cooperation, given that there is a kind of race? Do you see like-minded jurisdictions, and I would put the UK and the EU in that bag this time?
Well, in order to answer your question, I would like to reconnect with what Stephen was saying. And I think that traceability here is key. And it's not by chance that one of the first requirements provided under the MiCA regulation is you can offer, in simple terms, you can offer crypto assets as long as you are a legal person, which means having a company incorporated, basically. So a key point here is traceability. This is the major concerns, and I don't think it's going to be different in any other jurisdiction. Thinking long terms, I guess it depends on how this industry evolves. There will always be differences on how crypto assets are regulated. But I think that long term, at least certain principles will be regulated in the same way. If this doesn't happen through a proper institutional initiative, it's going to happen through the market. I'm not sure if this is going to happen for crypto, but I think it's going to happen through market as a result of this being a cross-border market in itself, if the phenomenon is, cross-border in its very nature, you can not think of dealing with it with a narrow approach.
I think with that, we have to close this discussion. So that's it for this Core Insights episode. I'd like to thank our guests, Luigi Cantisani and Stephen Murray. Luigi and Stephen, thank you. Thank you both. And for you listeners, I'll soon be back with another episode exploring the big issues in fintech. If you want to keep up to date with the latest research, thinking, and issues in fintech, be sure to sign up to the Core Insights newsletter. It will deliver all the analysis you need direct to your inbox. And a link will be in the episode's notes. Please also subscribe to the Core Insights podcast so that you don't miss the next episode in this fintech series with Warwick Business School's Gillmore Centre for Financial Technology. Thank you.